Good morning. Good morning, everybody, and thank you for joining us at our conference on international investment law, specifically Investor State Arbitration between Developed Democracies, a policy under challenge. This is a conference brought to you by the Canadian, CIGI, the Centre for International Governance Innovation, and specifically the International Law Research Program of CIGI. This project has been led by Armand Demetral. He is a senior fellow with the International Law Research Program at CIGI. He's also the Jean Monnet Chair in Law of International Economic Integration at McGill University. And Armand has put together this program for today with experts from around the world who are going to discuss different dimensions of this question of investor-state arbitration between developed democracies. And so the program, you all have a copy of that. It's divided up into 5 panels with an introduction to start the day by Armand. And then we have a lunch speaker who is the ambassador of the European Union, Marianne Konings, who will also discuss this issue from a European perspective. So I think we're going to have a really interesting day. You're also lucky to have both electronic copies as well as hard copies, if you wish to have them, of all the papers. So these are all draft papers, and they are being reviewed tomorrow in a closed workshop with the authors and the chief editor on the project. And the first result that will come from that is papers like this. You saw one of them was published, the first one. And there'll be a series of papers like this, and then we're also hoping to put them together in a compilation as a book. So that's all I have to say. Let me give you a more formal introduction to Armand. So I mentioned he's a senior fellow. He's been with us for over a year now. He is Professor Emeritus, and as I mentioned, the Jean Monnet Chair in the Law of International Economic Integration at McGill University. He teaches several courses, including Law of the Sea, Public International Law, International Trade Law, International Arbitration, European Union Law, and Public International Air Law. Professor Demetral's research focuses on areas of international trade law, law of regional economic integration, European community law, Canadian and comparative constitutional law, international environmental law, and international humanitarian law and human rights. I would also like to mention that today there'll be lots of opportunity for you to ask questions. So we're going to keep all the presentations fairly short. And if the speakers feel a little frustrated by being confined to a short presentation, there will be an opportunity at the end. The last hour and a half will be an open discussion with all the panelists, and you will have an opportunity to pose questions to the speakers then as well. So during the conference, after each panel speaks, you'll have an opportunity to pose questions live. And in that last panel, we'd ask that you prepare a written question, and then we'll sort through them, and we can hopefully get through more questions that way. Okay. I failed to introduce myself. I'm Una Fitzgerald. I'm the director of the International Law Research Program at CIGI, and I'm very happy to be here. So without more, I'll turn to Armand. Thank you.
Thank you very much, Una, for this very kind introduction. If I may, I'll say a few words about the organization of the day and very briefly introduce the general topic. You have an order of proceedings. You also have biographies of all our participants and our speakers. Just to say, the morning sessions will be focusing on the experience with investor-state arbitration in a number of jurisdictions. We have a very comparative approach, and we have presentations from the Antipodes to Canada, passing through Europe and the United States. So the focus of the morning, and 3 panels in the morning, is on national experience, the debate, the academic response, public criticism, etc. This afternoon, in the afternoon, we'll be looking at broader questions, one of them being, do the kinds of incremental changes that have been creeping into recent investor state arbitration clauses and investment protection agreements generally respond to the concerns of both the public, the academic and governmental levels. We also are looking at the question of how this fits into the broader picture, because we're focusing on the propriety of investor state arbitration between developed democracies, but obviously that we cannot ignore the broader international debate. And so we've devoted a panel to the question of what would be the response of the rest of the world where a number of developed democracies like Canada, US, Japan, EU, etc., to simply withdraw between themselves from investor state arbitration. And then we have a final hour-and-a-half question and answer session. And as Una pointed out, we have a very tight timetable for all our panels, and you may find yourselves frustrated in not being able to ask the questions you would like to ask. But there will be an hour-and-a-half where you, as the audience, will have your chance to put these questions. And I hope also that our panelists will feel that they have an opportunity to add certain points and say more things than they would have liked to say in their short presentations. At noon, of course, we're fortunate to have an address from Her Excellency, the Ambassador to the European Union. And of course, this is a jurisdiction of which Canada has recently signed a major trade treaty, including investor state arbitration. And in both jurisdictions, Canada, the EU, there has been and is a debate about investor state arbitration. And in many senses, we share common concerns. And I think that's reflected in the drafting of the CETA. Now, I would, if you haven't already had time to do so, warmly invite you to read the many papers that have been prepared. They are designed to reflect the experience of various countries, various developed democracies, with respect to investor state arbitration. And they're all available to you. They're available either online or in print form. And it's my hope that they will be published as CETA papers pending once the final review and the authors have had a chance to review them and make any further changes they deem necessary. And I hope that, as Una suggested, we will also be able to put out a collective volume reflecting the interest of the subject and the quality of the papers. As a general background paper, you have, in fact, the first CIGI paper, in which I've attempted to review the range of concerns that have been leveled against ISA, both by experts and in the public domain. And my paper attempts to present the many answers that have been given to these criticisms and the many solutions that have been proposed in recent years. And the paper also reviews the response of governments, particularly of Canada, to NAFTA and its subsequent practice in dealing with NAFTA and other more recent agreements, as well as suggesting possible courses of action most readily available to developed democracies at the present time. A second paper I've done looks in more detail at how Canada has responded to public pressures and criticisms of investor state arbitration, particularly in dealing with NAFTA cases and in preparing its model FIPA and negotiating subsequent agreements, especially CETA, whose drafting appears designed to protect the capacity of governments to adopt regulatory measures and goes further than any previous text in doing this. A third paper that I've prepared that is available to you looks at the question posed by the assertion one often hears that everything should be left to domestic courts, particularly Canadian courts, and that these courts can and should provide equally effective remedies, i.e. inaction and damages. In the Canadian case, unfortunately perhaps, the short answer is no, but I put the caveat that this answer can vary a lot from one country to another. And then the final paper picks up from the first paper and tries to set out the possible courses of action that seem realistically available to the Government of Canada. Now, just generally, should developed democracies abandon recourse to investor-state arbitration between themselves on the ground that it's neither necessary nor appropriate? This is the central question of the day. And there's a strong current of opinion that would approve this approach. There's been a debate in Canada almost from the moment that Chapter 11 of NAFTA was adopted in 1993. After all, it was designed to discipline Mexico. Excuse me, Hugo. No foreign investor was ever supposed to sue the Government of Canada, or still less the Government of the United States. But they've done so. And interestingly, I think Canada has produced some of the most principled critics of investor-state arbitration and some of the most extensive critical writing. And indeed, I know we're in an election campaign, I should be careful, but I think it's fair to say one national political leader has consistently taken the position contrary to investor-state arbitration since her days as the leader of a major environmental organization. And many see investor-state arbitration as a privileged legal remedy given to foreign investors. They're also concerned that the remedy appears to reflect private rather than public justice, even though it deals with a mix of public and private issues. I think it's fair to say Canada witnessed the first real debate in developed democracies over the propriety of investor-state arbitration, but the debate has spread to other developed democracies. As you'll hear today, Australia was perhaps the first to be so concerned that it declined to include investor-state arbitration in a major trade agreement with the United States in 2004. Subsequently, Australia appears to have adopted a more pragmatic position. European Union, whose member states invented investor-state arbitration, has witnessed a very hot debate over the propriety of recourse to investor-state arbitration with the United States and, to a lesser extent, Canada, since the EU has acquired competence over direct foreign investment in 2009. The debate has raged particularly in the European Parliament, but also in some of the member states, such as Germany and France. And there's currently a petition against investor-state arbitration in the TTIP with the United States, signed by several million Europeans. The fear of litigation with American companies seems to have elicited great concern not only within the EU, but also in Japan, where opposition to investor-state arbitration focuses on the TPP almost entirely in its aspect with the United States and seems to neglect other countries. You'll also hear about the experience of countries in Eastern Europe, Spain, Korea, in dealing with investor-state cases. So today's discussion focuses very much on the debate in developed democracies, but we cannot, of course, neglect the wider global situation where some countries have expressed opposition to investor-state arbitration or are in process of changing their approach to investment protection agreements. So is the debate over? Should developed democracies abandon investor-state arbitration between themselves and perhaps in all their treaties? I leave it to you to make up your minds at the end of the day. But in defense of investor-state arbitration, several things must be said. Criticisms in developed democracies have focused almost entirely on perceived objections when developed democracy governments are sued. And in the EU and Japan, almost entirely on the fear of the United States. Curiously, we Canadians don't seem to suffer from the fear of the United States quite as much as others. Perhaps we have more experience in dealing with Americans. And I think it's fair to say most critics virtually neglect the fact that the network of bilateral investment treaties and now investment chapters and regional trade agreements are designed to protect foreign investors abroad. Canadian foreign investors in distant parts of the world, where courts and governments do not always respect the rule of law, welcome the protection. Critics tend to focus on only one side of the equation. Another point that must be made is that international investment protection law is not fixed in time. It's constantly changing. If the concern is that investor state arbitration inhibits the regulatory process and allows foreign investors an unreasonable right to challenge domestic regulatory policies, critics would do well to examine carefully the changes made to model investment protection agreements, such as the US or Canadian models, as well as the many proposals for further change. Compare the procedural innovations we have that have been made to the practice of NAFTA Chapter 11, or which have been written into later agreements by Canada and other developed democracies. Consider the major exceptions, public policy protections, and other substantive changes that have been written into the CETA text by Canada and the EU, who appear to share very similar concerns. Much has changed. The substantive and procedural law is not static. There are important proposals to amend the ICSID review committee process. The EU has just last week proposed a court and appellate process for the TTIP. Further point that must be made is that developed democracy governments have lost few cases. The US, for example, has never lost a case. Finally, there's the need to ask why and how we've got in the position we're in. NAFTA Chapter 11 was adopted due to the concern, perhaps exaggerated, that the USA and Canada were being joined by a major developing country. For the EU, the concern is largely derived from the need to conclude the International Energy Charter, most of which of necessity must include both EU member states, but also a number of important energy-producing countries of the Caucasus and Central Asia. Would it have been possible for Canada and the USA and the EU to exclude ISA between themselves and maintain it for all these other countries? This is a complex and uncomfortable question that will be addressed today. In conclusion, I urge you to read the many papers that have been prepared. I look forward to your questions during the day. Ce colloque se déroule en anglais, mais la plupart de nos conférenciers peuvent répondre à vos questions en français, et on s'efforcera évidemment de répondre en français aux questions qui seraient posées en français. So, bon colloque. I hope you enjoy this conference, and I invite I have the members of the panel, and I will open it right away. I might say, and this would be an invitation to our panel chairs, we have a list of speakers with their bios. I think I will refrain from making the kind of description of each panelist, and I invite, in order to save time, I invite other panelists to do the same. We are indeed fortunate to have a group of very distinguished academic and professional participants who have prepared papers and who are presenting today. And indeed, I have to say, some of them are so distinguished and so active that they're not able to be with us today. One of them is in an arbitration in Washington and couldn't leave. Another is delivering a paper in Europe. But we're fortunate that equally distinguished and able colleagues have been able to replace them, and so we are able to proceed with a full conference. So, bon colloque, I thank you very much. So, without further ado, I would invite our panelists. Our focus in this first panel is on the reaction to investor state arbitration in Canada and the United States. And we have three very able and distinguished panelists. As I say, I will forbear from, I would refer you to the speakers' bios here. We're very fortunate that all of them have been able to join us. And I think I will invite David Gantz of the University of Arizona to lead off.
Can I get my PowerPoint up there?
Sure. PowerPoint.
Yeah. Great. All right. This is a paper, obviously, on looking at it at ISDS under U.S. law, politics, and practice. Just keeping in mind the U.S. was something of a latecomer to the BIT movement. We didn't really start concluding them until the early 1980s, which is almost 10 years after some of the European countries. The U.S., once it decided to go forward, became a very strong supporter of doing these ISDS provisions in bilateral investment treaties. A large part of it for the U.S. at that time was to replace formal or informal espousal, which got the U.S. government heavily involved every time there was a major investment dispute, which was a real mess in Latin America, particularly with Peru and Ecuador, and also having pushed very hard in the 60s and the early 70s for the broader acceptance of the concept that international law requires prompt, adequate, and effective compensation. It was considered a big plus to have these concepts more widely accepted. NAFTA, of course, was a transformative experiment for process for the U.S. as well as Canada. As far as I can tell, everybody was assuming that all of the investor state disputes would be between U.S. and Canadian investors and Mexico. Surprise, surprise, it didn't happen that way. They've been pretty evenly distributed among the three NAFTA parties as respondents. In the internal political process, the BITs have not been very controversial, partly because they only have to be approved as treaties by 2/3 of the Senate, with the idea of incorporating them into trade agreements like Chapter 11 of NAFTA. They get caught up in the broader debate over pros and cons of trade agreements and all the issues that arise from there. Again, the formal espousal concept wasn't that common, after the 20s and 30s, but informal espousal by the State Department with these disputes in the 60s and 70s was quite common. I spent 7 years in the legal advisor's office at the State Department in the early 1970s, and most of my time was spent trying to resolve investment disputes in Latin America. The U.S. government negotiated many settlements, particularly in Peru and Ecuador, pretty much on a case-by-case basis. This whole process was accompanied by threats of sanctions, the Hickenlooper Amendment, cutting off foreign aid, cutting off support in the international financial institutions, and the result typically was that these disputes tended to dominate bilateral relations, and if the country like Peru or Ecuador happened to be a member of the Organization of American States, the U.S. Delegate was frequently subjected to not entirely unreasonable charges of economic coercion. I spent a lot of time listening to those issues many years ago. And you had this rather strange process, at least from the point of view of a lawyer and due process, of relatively young State Department lawyers listening to an American company complaining about his treatment in a particular country, and then trying to decide whether those complaints were valid, and becoming an advocate essentially on that entity's behalf. So it wasn't really surprising that beginning with Reagan, then the first Bush administration, the Clinton administrations, everyone in those groups became relatively enthusiastic supporters of concluding bilateral investment treaties, all of them, at least for the U.S., with ISDS. The process evolved slowly. Some of you were familiar with the multiple model BITs that came out every few years, typically. Most of the changes, at least until 2002, were relatively minor. In almost all of these BIT situations, the other party was a small developing country or a medium-sized developing country where although the agreements were totally reciprocal, the chances of, for example, in the most recent ones, an investor from Uruguay suing the U.S. government under the BIT that was concluded a decade or so ago were really pretty small, if not totally insignificant. NAFTA, of course, was a big change. Despite the assumptions, the U.S. has been asked or noticed to go to arbitration in close to 20 cases, although not all of them went forward. If you looked at the NAFTA negotiations and some of the statements, this was a big part of what President Salinas and his colleagues wanted to see happen in order to encourage investment, the transfer of technology, creation of jobs. And so it wasn't one of these situations, as far as I can tell, where Canada, the U.S. forced investor state dispute settlement on Mexico. It was accepted, if not enthusiastically, certainly as an integral part of a package that was going to, and has successfully, I think, increased investment in Mexico, exports, and all of those other positive things. There was some innovation in Chapter 11, but a lot of it just followed some of the earlier Model BIT experiences. And again, for the U.S., at least for some officials, the idea that Mexico, long a proponent of the Calvo Clause, was willing to accept ISDS was also considered a major diplomatic victory in the U.S. But of course, as we all know, whether you're a government lawyer or a private lawyer, nothing clears the mind like being the respondent in a major case, particularly one that has a very high profile, where losing it can adversely affect your career or your ability to get clients. And by 2000, there were multiple cases, obviously pending against all three NAFTA parties. And the governments, I think, uniformly decided that there had been some things about NAFTA that ought to be changed in the future. The breadth of fair and equitable treatment, an interesting concept where the governments unanimously decided that nothing had changed in this particular area of customary international law since the Near case in 1926, while almost all of the arbitrators, except for one or two cases, said, no, there's been an evolution, and you don't have to have a situation that totally shocks the conscience or is outrageous before you have liability. And the whole area of regulatory takings, which we see most recently in the Bitcom case. In the U.S., by the time, and particularly with Methanex, the case in California, by the time of the Trade Promotion Authority, the authorization that the U.S. government needs in order to effectively implement free trade agreements. It doesn't affect BITs at all in a significant way, except the same basic theories apply. By the time we were doing new agreements under the second Bush administration with Chile and Singapore, they were trying to redefine concepts, especially to deal with regulatory takings, the rare circumstances language that if it's non-discriminatory, regulatory actions protecting things like public welfare and safety and the environment, particularly the environment, are not indirect expropriation. That was one area. And then this whole area of fair and equitable treatment, customary international law minimum standard, don't have to do anything beyond what is required by that standard. The problem is it doesn't tell you what customary international law is, and I think most commentators, and certainly the vast majority of arbitrators, other than the Glamis Gold case in the U.S., see it as an evolving process that is affected, among other things, by 3,000 BITs and all of these, some 600 ISDS cases that we know about. One of the interesting things that is that there was an effort to adopt U.S. Supreme Court litigation. How much time? Okay. U.S. Supreme Court litigation from the Penn Central Transportation Company case. It's not so surprising that this is brought into the U.S. investor state chapters, but it is also found in the Canadian agreements and this newest proposal that comes out of the European Commission. The informal proposal also has the same language from Penn Central, which I find sort of a creeping imperialism, but a standard which obviously is very desirable for many lawyers in various jurisdictions. There was a huge fuss, again, when the Congress changed in 2006, and from that time on, the FTAs said that foreign investors in the United States will not be accorded greater substantive rights than they get under the Fifth Amendment and other guarantees, legal and constitutional, in the United States. And this appears in agreements with Korea, Colombia, Peru, and Panama, and it almost certainly will appear in the Trans-Pacific Partnership language as well. Again, they redid the Model BIT in 2012. It took about a 3-year period under the Obama administration. Not really many changes except a few on the periphery. There was a huge debate, as some of you know, earlier this year over renewing the Trans-Pacific Partnership, and ISDS was one issue, but only one of several issues that was part of the discourse, and it really wasn't that different than the NAFTA debate. If you go back and look at Ross Perot when he was running for president, you'll see a lot of the same language. As usual, a lot of Democrats, labor unions, and environmental groups don't like trade and investment agreements at all, not just the ISDS, but many other concerns about encouraging job losses for American workers in the world environment. Again, there was a fairly sophisticated debate by some people who are sitting in this room, some who are not, over the original objectives, including getting the U.S. government the heck out of the business of negotiating these issues, and others like the Cato Institute, Simon Lester, saying, well, it's part of the risks of investing in countries with weak rule of law. Buy political risk insurance from OPIC, unlike the Exim Bank. That agency still exists. And a few, but very few, says, well, let's try to improve the process. At least the European Union is looking at it from that point of view rather than totally getting rid of the whole idea. But again, it seems to me, given my background, that if you get rid of ISDS, the State Department will be back in the business inevitably of negotiating these agreements, simply because congressional and business enterprise pressure will be overwhelming. Otherwise, in the future, again, we're hopeful that the Trans-Pacific Partnership will be done in a few weeks. I think the language is pretty much going to be the same as we've seen in recent agreements. It'll look very much like the Korea Agreement, for example. They're trying to negotiate a BIT with China. Canada did this a couple of years ago, but there's a lot in that agreement that the U.S. will never accept. It's a very complicated process because we all know that if there is ISDS, the U.S. will be respondent just as much as U.S. government official, as U.S. enterprises will be bringing cases. So it will be very interesting to see how that all goes. TTIP, we'll be talking about that later, so I'll just skip this part. Someday, I think the Commission will probably make a formal proposal, maybe by the end of this year. Whether the U.S. government and stakeholders will accept this idea of an investment court, I guess we'll talk about later in the day. And one of the concerns I have in the U.S. is whether U.S. stakeholders really care much about the TTIP investment and other provisions. Thank you.
Thank you very much, David. I'm sorry to rush you. I know there's a lot to be said. All right. Now I invite Charles-Emmanuel Côté to speak from Canada.
So you did not receive my PowerPoint. Don't worry. Don't look for it. I didn't send one. I will talk about the Canadian side of the story of Investor State Arbitration. I will start with some data. One interesting point to make at the outset is that for the moment, Canada is the most experienced developed democracy with investor state arbitration. No other developed democracy has faced as much claims than Canada. So Canada can claim to have the status of the most experienced developed democracy with investor state arbitration. Obviously, all claims were brought under NAFTA Chapter 11. All claims were brought by a U.S. investor as well. For the moment, we have 22 claims that were brought. Most of these claims were against environmental measure, unsurprisingly enough. Some claims were also about state-owned enterprises or public services. For the most part, the claims related to these issues, measures relating to these topics. In addition to those 22 claims, there are probably 15, but Armand and I disagree on the exact amount of notice of intent to submit claims to arbitration, and the reason is that the data is not exactly the same depending on what source you look in. I personally checked on the Department of Foreign Affairs website, and they list 15 notices of arbitration, of intent to submit claims to arbitration. But if you look on some other sources, you might see other notices that were not reported by the federal government. Those notices, even though they never led to an actual claim, they are part of the story because they might have fueled fears of investor state arbitration. Even if they had actually no real legal basis, they were made, they were publicly available, and they might have raised fear as well. So out of those 22 claims, 11 are now closed, and Canada won 7 and lost 4. The aggregate amount of claims that were brought against Canada, or including those that are still pending, is $8.1 billion US. However, when you look at the actual damages that were awarded or the settlements that were reached between the parties, the number gets to $147 million US, which equates to a mere 0.05% of all US investments in Canada. So that has to be put into perspective as well, like the amount of stocks of US investment in Canada versus the actual damages that were awarded against Canada. So my main point would be that overall the experience of Canada with investor state arbitration has not been as dark as one might think, even though there are some areas of concerns. And I will look at these lessons that may be drawn in the few minutes that I have left, the few lessons that may be drawn from the Canadian experience. Like the US, and even later than the US, Canada has been also a late participant, a late bloomer in investor state arbitration or investment treaties. Our first treaty was signed with the US actually in 1989 in the Canada-US Free Trade Agreement. There was an investment chapter which did not include investor state arbitration, but only disciplines on investment policy. Since then, Canada has signed 29 foreign investment protection and promotion agreements, FIPAs, all including investor state arbitration, 7 of which are with developed democracy, all of which are former Central and Eastern European countries that are now member of the EU. We also have 11 free trade agreements into force. And they do not systematically include an investment chapter or investor state arbitration. Out of these 11 FTAs, we have 3 FTAs that are with developed democracies, NAFTA obviously, but we also have a free trade agreement with EFTA countries, the European Free Trade Association, and this free trade agreement does not include an investment chapter. We also have a recent free trade agreement with South Korea that includes a free trade, an investment chapter with ISA. We have obviously also under negotiations or that are not yet into force a couple of treaties, CETA with the EU that we've talked about already, TPP, Canada is participating, and also free trade negotiation with Japan, and I'm not sure exactly if there is plans to have ISA or not. This data is not publicly available at the moment. Last important point is that in Canada, foreign investment agreement, FIPAs or FTAs are not part of the law of Canada. They may not be invoked before Canadian courts. So that is important in the discussion in order to know whether there is an additional protection that is granted to foreign investor in Canada. But the disciplines in the treaties may not be invoked directly before Canadian courts. If I look quickly at in the time that I have left at some lessons that may be drawn from the Canadian experience, one thing that should not be forgotten is that a lot of the obligations that are provided for by these treaties are already binding on Canada in other ways. There are some, of course, international customary law obligations that are already binding on Canada. There are some WTO law obligations already binding on Canada that may be repeated in these treaties. There are also some we tend to forget, but there are some old treaties of friendship, commerce, and navigation that were signed by the United Kingdom that are still binding on Canada. Some of them are still binding on Canada, and they do provide for disciplines as well that might equate or echo what we find in investment agreements. Another point is that it could be, and that issue has to be looked, I guess, more into details. It could be that Canadian law does not offer always equivalent protection than you have in investment treaties. We have had the case of Abitibi-Bowater with the direct expropriation by a provincial government, where we face the limits of our internal law facing these issues, and that shows that maybe there's a need for international protection there. We have a pending case now at the Quebec Superior Court that could be interesting in that regard as well. In the Stratico Resources case, a Quebec mining company is suing now the Quebec government for 190 million Canadian dollars because its mining exploration operations were stopped by the provincial authorities for lack of social acceptability, despite previous temporary authorization, despite the Federal Nuclear Safety Commission approval of the project, and they're now testing the limits of the Canadian law in the Canadian courts, and that might be interesting to see how far you can get protection. The facts in that case resemble to facts that you might find in Investor State Arbitration. Quickly, maybe the two main problems that I see from the experience of Canada in terms of substantive law, I believe that the most favored nation clause at the moment might be problematic. Even though you might, in newer treaty, limit the scope of most favored nation clause, that does not alter the fact that in previous treaties, like in NAFTA, for instance, you have an unlimited most favored nation clause, and that way, even if you have treaty innovation for posterior treaties, the previous treaties are still the MFN clause is still not limited. So in a lot of cases brought against Canada, investors do invoke better treaty protection in previous FIPAs, for instance, in order to bypass limitations that have been made in later treaties. And I think that's an area of concern for Canada and for most developed democracy. I think it's an issue that has to be more looked into. There's no definite ruling, however, yet on if one might use the MFN clause in that respect. Each time the question was put before an arbitral tribunal, they decided to duck the issue and rule differently without saying that they refuse to, they accept either argument, just saying that they refrain from ruling. Obviously, the second area of concern is the fair and equitable treatment clause. I would say that we kind of witness a slow nullification of the notes of interpretation that were adopted in 2001 to restrict the scope of the fair and equitable treatment protection in NAFTA. Why is that? Well, first of all, with the idea that the content of, which is, I guess, a right idea, that custom is not fixed in 1926 and is evolutionary, well, there are limits to what you can circumscribe at one moment. In 2001, custom continues to evaluate. to evolve, and what we see is that there seems to be less relevancy in this specific notes of interpretation in recent interpretation of the fair and equitable treatment. And of course, even if arbitrators agree on the content of customary protection, still what we see, and the Clayton-Bilkin case is the latest instance in that regard, what we witness is that this general protection is quite hard to apply to the facts, and arbitrators might completely disagree in applying the fair and equitable treatment protection to the facts, which leads to other problems. Maybe another point that I find interesting to stress, and there are so many other things I would like to say, but one interesting issue is the use of denial of benefits clause. Canada has, in most of its treaties, included a denial of benefits clause, like in NAFTA, allowing it to block claims by shell corporations, controlled by third country foreign investors that have no substantial business in, say, the US. The clause was invoked outside legal arbitration proceedings in one case, and it was successful enough to stop the proceedings. So it was invoked, it was not ruled on by arbitrators, but one should nevertheless look at other instances in which outside NAFTA such clauses were applied. Importantly enough, in the UCOS trilogy arbitration case, the tribunal ruled that such a clause could not be invoked retroactively. And that means that it's not clear how exactly such a denial of benefit clause has to be handled by treaty parties. So that's an area that has to be looked more into detail. Maybe the last experience in my minute, that is the last minute I have, maybe even though the notes of interpretation for the fair and equitable treatment have proven to be of a limited interest in time, I still believe that it's probably the most pragmatic mechanism to control ISA at the moment, given the impracticability to modify most treaties that are already in force, to introduce appellate review, etc. Probably that for the moment the most pragmatic solution is binding interpretation, and perhaps that countries should use more often binding interpretation in the operation of their treaties. And it has been, like you know, very scarcely used, at least in fact only twice in NAFTA and for the Canada-Chile free trade agreement. For the rest, it has never been used, and I believe it should be used more often. Yes, I will end here. Thank you.
Thank you very much indeed. I invite David Schneiderman to take the floor.
Good morning, everyone. I don't know about you, but it feels like springtime in Iqaluit in the room. It's so cold. Thank you very much to Armand and to my co-panelists who've written some really excellent papers. I've been asked to first talk about some of the critiques that have been generated by scholars and civil society, and then to turn to my paper if I have any time. I should mention that the paper has not been circulated before. That is, you will have seen it for the first time, and so I very much welcome comments, criticisms, etc., genuinely so. Okay, so let me briefly survey criticisms that have arisen in response to ISDS. As Charles Emmanuel says, Canada was the first to experience ISDS as a developed state, and so a lot of this criticism really took root here and circulated. One thinks of, for instance, the debates around the multilateral agreement on investment in the mid-90s. Much of the information, arguments generated here circulated around the world to other states and social movement actors. So we've had a great deal of experience. In fact, I think Judge Schwabel in a recent speech complains that lays the blame for criticisms of ISDS at the feet of two Canadians. Any of you seen this? It might be Howard Mann. It might be Gus Van Harten. I'm not sure, and I'd flatter myself if I thought it included me. Firstly, the regime, if I can call it that, is unstable and unpredictable. The standards that are enforced by investment tribunals are vague, uncertain, and continually evolving, resulting in a lack of clarity for states. This is from Charles Emmanuel's paper, talking about fair and equitable treatment, which F.A. Mann in the 1980s said had no discernible content, but he was making proposals about what could fill in the content of that standard. Charles Emmanuel describes as having a serious lack of legal predictability in his paper. Tribunals taking an expansionist, or as Jefferson called it, latitudinarian approach to interpreting these standards. And I think that this was true at the outset. One thinks of, for instance, the Metal-Clad Tribunal's definition of what is a compensable taking, the American term, which has been entirely overtaken, it seems to me, and Charles Emmanuel in his paper says that fears about expropriation or takings weren't realized. Well, that's because the expropriations, it seems to me, were entirely overtaken by fair and equitable treatment, which incorporated some of the considerations that go into determining whether there's been a compensable event. In other words, some of the Penn Central criteria that David Gantz mentioned reappear in fair and equitable treatment considerations. There's a structural tilt to the regime, and not surprisingly, right? The object and purpose is to facilitate capital movement. There are claims about bias, hard to prove, and certainly hard to disprove. There's certainly a selection bias in choosing what law to source as informing the content of international investment law, selection bias, that is, that favors capital exporting states. It's not the constitutional law of South Africa, for instance, which is circulating as a possible way of interpreting expropriations, right, which is very different, discordant with the trend lines in international investment law. But there are discernible systemic tendencies, and Gus Van Harten has done some recent work on this, 160 cases. He does content analysis of these decisions around jurisdiction and substantive interpretation, and finds that investors from capital exporting states in a statistically significant way are more favored by tribunals. Resulting in regulatory chill. This too is hard to prove. Some say you just count the number of disputes, so there's no regulatory chill. Look at the few number of cases and, of course, statute books and codified regulations. The European Federation for International Law and Arbitration, I think it's EFILA, says you can't do this, just give it up. There is no regulatory chill. And that doesn't sound right. We get conflicting anecdotal accounts about what's going on, and certainly my introduction to international investment law occurred in 1994 when the Canadian government considered adopting a plain packaging initiative in regard to the sale of tobacco products, which is, of course, a large controversy now, disputes against Uruguay and Australia. It's forgotten that Canadians actually considered this very proposal and abandoned it for any number of reasons, and I think it's reasonable to assume that the threat by Carla Hills, former USTR, that 3 major American tobacco companies would sue for hundreds of millions of dollars would have been a factor, right, in the Canadian government's determination to abandon the plain packaging initiative in 1994. Is the system then in crisis? Some people say it is. Sona Raja says yes. And of course, there are events in Germany and France, and we'll hear more about this, of course, as the day goes on. South Africa is withdrawing. India has offered a different kind of model. Brazil, something entirely different. But like most people in the room, I would think that it's not in crisis, actually. It's unlikely that the regime is going to simply disintegrate. That's because there are powerful economic interests, and there are lawyers, right? Some of them gathered in the room, who will ensure that the regime continues on. It will be difficult, it seems to me, to dismantle this global web, right, of investment treaties, which does not explain the hyperbolic and vitriolic attacks launched against critics by international investment lawyers and arbitrators. It's very curious how angry some of these folks are, and I would refer you to the piece by Brower and Blanchard in the Columbia Journal of Transnational Law. It's just really inexplicable, the accusations that are being flown around, namely that, we, critics, are misleading, liars, myth makers, etc. Okay, let me turn to my paper. Let's see how much time I have. Okay, I have 3 minutes. So the paper, after sort of listing in a short paragraph some of these criticisms, takes seriously democracy-promoting rationales that have been offered by tribunals and some investment scholars. Democracy-promoting rationales for ISDS. So this is a paper about democratic theory, and listening to the complaint that investors have no voice in host state political processes. They're not represented, right? Because they're not represented, they're vulnerable to changes in state policy and targeting, and it's the story of the obsolescing bargain, right? Investors are not going to be represented. Well, of course, companies, artificial persons don't have a vote anyways in most jurisdictions, and there are many ways in which foreign investors express themselves, have a voice, and there's literature out there, it's political risk literature, among other things, that tells us the ways in which companies make their views known to host states, and many of you, I'm sure, are familiar with some of these techniques. But nevertheless, I want to take seriously the argument that foreign investors should be heard. That is, states should listen to investors. And I'm pursuing here an idea that's been promoted by Jürgen Habermas in our global legal, economic, and political environment, that there are many of those who are affected by national laws that don't have a voice, that aren't represented. So we want to take into account all of those affected when we make policy. And that includes not just foreign investors or foreign nationals, but also communities, right? And other folks who might not actually have a voice. It's interesting, for instance, in the TechMed dispute, that the citizens movement that was opposing the operation of the hazardous waste site because of the environmental dangers that it posed, and which were documented by the Mexican government. There was also a push for freedom of information because the local community felt it was left out of deliberations that were taking place between the investor and the city and the state. So freedom of information. So the community wanted to be heard as well. They were affected. And I do this by pursuing the idea of listening, hearing the other side, represented by the Latin maxim audi alterum partem. And I, in the paper, trace some of the political theory behind audi alterum partem, which gets taken up in English administrative law and in other English-derived legal systems. And it's not a set formula, but just a general kind of rule. Listen, hear, deliberate. It does not, a process-based account does not resolve substantive disagreement, but it allows for hearing and dialogue. I examine a number of disputes where listening to the other side may or may not have changed the result. I talk about Methanex and Chemtura as instances where the investors were heard and wouldn't have resulted in a change in the tribunal's decision. Of course, Audi Altrum Partum, I should make clear, is about having local processes, host state processes, listen, rather than having investment arbitrators do the listening. TechMed, I suggest, would have led perhaps to better treatment to the investor, and in Bilcon certainly would have led to a different result, that is, the investor had lots of opportunity to reply to concerns about environmental hazards before the joint review panel. And then I address a number of counter-arguments. That is that there's local host state processes that listen to investors are no substitute for international arbitration. Hugo Periscano makes this argument in his paper. It's distinct from national law, and in some respects, yes, in many respects, no. The argument, the no substitute argument, ignores the source for the content of much of what constitutes international investment law, including, as we learned from David Gantz, the American Constitution. It also ignores some functions that investment tribunals perform, as in Bilcon, performing functions that are ordinarily performed by domestic tribunals, right, by courts within the host state. There are arguments that investment law already provides due process. It's true, there's a hearing. Not everybody's heard from, but there are provisions for doing that. But of course, it's much more than a process. International investment law is enforcement of substantive norms. And lastly, the argument, and this I've heard from World Bank officials, that without ISDS in the background, you'll never get host states to improve local processes, right? Court administration and the rule of law. You need ISDS as a threat, right, to hammer host states over the head. And this sounds kind of possibly convincing, but how does one explain then the rapid rise and embrace of ISDS, of BITs and FIPAs in the 1990s into the 2000s, when there was no such hammer hovering over the head of host states, when there was no system like that as a threat operating in the shadows? And so I suggest that, in fact, you don't need ISDS as a threat in order to promote rule of law reform of the sort that I'm describing. Now, is this likely? No. Jan Paulsen, in his book Idea of Arbitration, makes note at page 258, I'm ending here, Armand, and he writes this tongue-in-cheek, right? He says, some academics have suggested that international arbitration should be jettisoned because its availability stifles the evolution of national courts in institutionally immature states. And he just does not see this as, it would require an ethical epiphany on the part of those local judges. In a footnote to this point about some academics, he says this: no references are given. If the reader doubts that such notions could seriously be put forward in scholarly writings, so much the better. Right? It's better that you think it's just completely made up. So, what I want to close with then is the thought that this is unlikely to be embraced by international investment lawyers and arbitrators, but I think it's worth thinking about. It also rubs, interestingly, against the law and development scholarship, including that promoted by the World Bank, about developing rule of law reform, about improving host state processes, including those that enable decision makers to listen to the other side. Thank you very much.
Thank you very much, David. Our three speakers have kept to their timetable with exemplary precision and left us 14 minutes for questions. And I would welcome questions to any or all of the panelists. And I would invite any possible questioner to identify themselves and pose their question briefly and concisely. Thank you. Please.
Todd Weiler, these are actually just really quick points. It was actually the Carter administration, David, that started negotiations on BITs, even though Reagan was the first one to negotiate one. Just wanted to make that point. And with David, the reference you made to F.A. Mann is actually, there's a whole big footnote in my book about it. He was actually talking about exchange controls. He wasn't talking about the minimum standard. And I could make you the reference for it so you can see it.
I'm happy to give you my reference.
Well, no, I know your reference. I actually, 3 people have made this incorrect inference before, and it's there.
I'm hoping then that your book explains what the content of FET was in 1983.
Well, as a matter of fact, it does.
Okay, good. Good.
Interpretation of Investment Law, Brill, 2013.
Sir.
Thank you, Professor Metcalf. I'm Howard Knopf, KNOPF. I'm an intellectual property lawyer. I put to whoever wants to take this on one case that has not been mentioned, and arguably it's the elephant in the room, concerns Canada, which is the Eli Lilly challenge, Investor State challenge currently pending, where, to characterize it reasonably neutrally, Eli Lilly lost a patent case in the federal court, of Appeal. The Supreme Court of Canada turned down leave to appeal. Eli Lilly's not happy with that result and has brought a $500 million claim against Canada, in effect trying to go over the head of the Supreme Court of Canada. So this is not a claim about our patent law, it's really a claim about our jurisprudence. It's not unrelated to the situation in Australia that was mentioned involving plain packaging, and as many of you in the room, probably all of you know, the Chief Justice of Australia, Robert French, who is a sitting Chief Justice, not a retired one, has spoken out very harshly about ISDS and saying quite explicitly that it offends notions of sovereignty and rule of law. And it was interesting that the plain packaging situation was mentioned here. I had done some work on that in the past, and it seems to me that plain packaging would be a perfectly reasonable initiative under health law. And I think some of us would be concerned if, for example, at some time in the future, Smith & Wesson was to bring a complaint that we don't allow advertising guns in Canada and we ban handguns. Anyway, I'm trying to roll a lot into here, but maybe we focus on the Eli Lilly question and whether or not it is troublesome for us that, in effect, 3 arbitrators could overturn the decision of a federal court of appeal and leave to appeal denied by the Supreme Court of Canada.
Thank you.
Well, in my paper, I address very briefly the Eli Lilly case. Obviously, the case is not yet concluded, but a few questions flow from this case. First of all, there's in the arguments of the investors, there's this, they try to make a link between alleged violation of the intellectual property chapter of NAFTA and that could help to constitute a breach of the investment chapter. And these sorts of arguments have been made in earlier case, and in that case it seems to be central in the argument that breach of intellectual property protection in NAFTA would constitute a breach of investment. And that has not been successful before. There has been a clear will to separate investment chapter from other chapters and evaluating if there's a breach of the investment protection provisions. Even the notes of interpretation of Chapter 11 made that clear, that violation of another NAFTA chapter cannot constitute a breach of minimum standard of treatment. But the argument is put again. A second interesting point there is that, and that goes to what you said about the fact that fair and equitable treatment might have encompassed some aspects of expropriation. And in in my reading and my understanding, and I'm not an intellectual property lawyer, but my understanding of that case is that there's a fair argument that is fair. There's an argument that is made that it's constituting a direct expropriation, basically. That the losing of the patent is a direct expropriation. That's an argument that is made, and there were few cases where direct expropriation claims were made. Again, not indirect, but direct expropriation against Canada. That is troublesome, I guess, but I don't know to what extent it's going to fall on fair and equitable or direct expropriation. And more broadly, this case, I think, touches on something I explored a little bit more in detail in the paper. It's the limit between trade disputes and investment disputes, and the fact that in trade disputes, private investor or private economic operators do not have an international remedy, apart from asking their state to espouse their claim and bring a complaint, tend to use investor state arbitration to try to frame or to clothe a trade dispute in an investment dispute in order to get a satisfactory remedy. And this has happened in quite a few cases, and I even believe that it's maybe more likely to happen in relation to investment chapters embedded in free trade agreements. There's like a closer connection between the trade and investment thing than with an autonomous bilateral investment treaty. And I think that's something that has been maybe a little bit underlooked. Is there a difference between an investment chapter in a FTA or a bilateral investment treaty? And I would tend to think that basic treaty interpretation rules that makes the interpreter, that forces the interpreter to interpret a provision in light of the objectives and of the goal of a treaty, then if you're in an FTA, the goal and the objectives are broader and encompass trade and investment, and there's sort of blurring of trade and investment issues that can lead to more easily clothe a trade dispute into an investment dispute. That would be my...
Just a short comment. We have to be careful about how we talk about investment arbitration in relation to domestic law. In Canada, as Charles-Emmanuel has suggested, Canadian courts in a couple of cases, the Cupie case and Kapatsach, I think, case, basically declared that investment arbitration is a subfield of international law. It's a separate and distinct legal system, having no impact on Canadian law. That's how the Ontario Court of Appeal describes international investment law, separate and distinct. So Canada commits internationally. It'll pay damages if it's liable, but we don't change, nothing gets changed internally. So when we talk about investment arbitrators overturning a federal court judgment, that wouldn't quite be right. But then the courts, of course, draw this artificial line because, practically speaking, Canada will not want to face a multitude of these kinds of claims, and so will change its policy, right? In order to forestall that possibility, it'll have to pay out and then avoid paying out further claims by changing the law, right? And so doing functionally, practically speaking, what you're describing.
Well, if I can, brief follow-up, if I can be permitted, not maybe a question of changing the law, but what they're trying to do is basically an end run around our courts, and our courts at a very senior level up to Supreme Court of Canada. But do any of you think that the Canadian government was wrong or is wrong to argue this on the merits, and maybe should have brought a challenge as to the very jurisdiction, in effect, for Eli Lilly to challenge a court decision? If they want to challenge the Patent Act, fine. I don't think they have they obviously don't think they have a leg to stand on. What they're doing is basically challenging, in effect, the court decision.
I don't know the case well, but there have been a number of other NAFTA cases, Zinian against Mexico and Lowen against the United States, where it was pretty clear that those tribunals looked at a challenge based on a completed court process in those countries as more a traditional international law question of whether there was a denial of justice, not an issue of whether the court, the Canadian court, the U.S. court, I guess it was the Louisiana court, the Mexican courts were wrong or correct, but a question of a very, very high level of review. And I would hope that in this case, the tribunal would take the same approach. I think there's jurisprudence in NAFTA tribunals that suggests that the standard at which they're looking is a much higher and more difficult one to meet. It's not a fork in the road question where you start out in local courts and then you shift to Chapter 11. This is a case where you've had the entire court process completed. So frankly, I would be very, very surprised if the tribunal found in favor of the claimant in this kind of a situation, just because again, I don't know who the arbitrators are, but this is very well established, I think, under international law, entirely apart from Chapter 11. So that would be my guess. And the other point I would make is, you talked about Philip Morris a little while ago. That's the kind of a case I think that would be much harder to win under one of the more contemporary investment chapters, where you have this, except in rare circumstances, health and safety, among other things, are not a basis for an indirect taking. NAFTA doesn't have that language. The Trans-Pacific Partnership will, I believe. The agreement with Europe also does. Certainly most of Canada's recent FTAs have that kind of language. In a lot of cases, I don't think it would make a lot of difference, but I think it would make a huge difference here with Philip Morris. Finally, you talk about the interaction of trade and investment issues, which again is exemplified by Philip Morris, because they're pursuing a number of parallel tracks, several of which are investment treaties, but also one of which is at the WTO, seeking to show that somehow the Australian actions are a violation of the TRIPS agreement. Frankly, I think the chances of seeing there at the appellate body are exceedingly slim. It's hard to predict what individual investment tribunals will decide.
Thank you.
I'd like to thank our panelists for opening our day's debates, and I think Una has a moment to.
Yes, thanks very much for a wonderful panel. Charles-Emmanuel, David, and Armand. That was a great introduction to where we are in North America. So let's give a big hand to the panel. And thank you for the interesting questions from the audience.
And of course, this is a jurisdiction in which Canada has recently signed a major trade treaty, including Investor State Arbitration. And in both jurisdictions, Canada, the EU, there has been and is a debate about Investor State Arbitration. And in many senses, we share common concerns. And I think that's reflected in the drafting of the CETA. Now, I would, if you haven't already had time to do so, and warmly invite you to read the many papers that have been prepared. They are designed to reflect the experience of various countries, various developed democracies, with respect to investor-state arbitration. And they're all available to you. They're available either online or in print form. And it's my hope that they will be published as CETA papers pending once the final review and the authors have had a chance to review them and make any further changes they deem necessary. And I hope that, as Una suggested, we will also be able to put out a collective volume reflecting the interest of the subject and the quality of the papers. As a general background paper, you have, in fact, the first CIGI paper, in which I've attempted to review the range of concerns that have been leveled against ISA, both by experts and in the public domain. And my paper attempts to present the mental changes that have been creeping into recent investor state arbitration clauses and investment protection agreements generally, respond to the concerns of both the public, the academic and governmental levels. We also are looking at the question of how this fits into the broader picture, because we're focusing on the propriety of investor state arbitration between developed democracies, but obviously that we cannot ignore the broader international debate. And so we've devoted a panel to the question of what would be the response of the rest of the world where a number of developed democracies like Canada, US, Japan, EU, etc., to simply withdraw between themselves from investor state arbitration. And then we have a final hour-and-a-half question and answer session. And as Una pointed out, we have a very tight timetable for all our panels, and you may find yourselves frustrated in not being able to ask the questions you would like to ask. But there will be an hour-and-a-half where you, as the audience, will have your chance to put these questions. And I hope also that our panelists will feel that they have an opportunity to add certain points and say more things than they would have liked to say in their short presentations. At noon, of course, we're fortunate to have an address from Her Excellency, the Ambassador to the European Union.
At the end, the last hour and a half will be an open discussion with all the panelists, and you will have an opportunity to pose questions to the speakers then as well. So during the conference, after each panel speaks, you'll have an opportunity to pose questions live. And in that last panel, we'd ask that you prepare a written question, and then we'll sort through them, and we can hopefully get through more questions that way. Okay. I failed to introduce myself. I'm Una Fitzgerald. I'm the director of the International Law Research Program at CIGI, and I'm very happy to be here. So without more, I'll turn to Ahmad. Thank you.
Thank you very much, Una, for this very kind introduction. If I may, I'll say a few words about the organization of the day and very briefly introduce the general topic. You have an order of proceedings. You also have biographies of all our participants and our speakers. Just to say, the morning sessions will be focusing on the experience with investor state arbitration in a number of jurisdictions. We have a very comparative approach, and we have presentations from the Antipodes to Canada, passing through Europe and the United States. So the focus of the morning, the three panels in the morning, is on national experience, the debate, the academic response, public criticism, etc. This afternoon, in the afternoon, we'll be looking at broader questions, one of them being, do the kinds of incremental
European perspective. So I think we're going to have a really interesting day. You're also lucky to have both electronic copies as well as hard copies, if you wish to have them, of all the papers. So these are all draft papers, and they are being reviewed tomorrow in a closed workshop with the authors and the chief editor on the project. And the first result that will come from that is papers like this. You saw one of them was published, the first one. And there'll be a series of papers like this, and then we're also hoping to put them together in a compilation as a book. So that's all I have to say. Let me give you a more formal introduction to Ahmad So I mentioned he's a senior fellow. He's been with us for over a year now. He is Professor Emeritus, and as I mentioned, the Jean Monnet Chair in the Law of International Economic Integration at McGill University. He teaches several courses, including Law of the Sea, Public International Law, International Trade Law, International Arbitration, European Union Law, and Public International Air Law. Professor Demetral's research focuses on areas of international trade law, law of regional economic integration, European community law, Canadian and comparative constitutional law, international environmental law, and international humanitarian law and human rights. I would also like to mention that today there'll be lots of opportunity for you to ask questions. So we're going to keep all the presentations fairly short. And if the speakers feel a little frustrated by being confined to a short presentation, there will be an opportunity. Good morning. Good morning, everybody, and thank you for joining us at our conference on international investment law, specifically Investor State Arbitration between Developed Democracies, a policy under challenge. This is a conference brought to you by the Canadian, CIGI, the Centre for International Governance Innovation, and specifically the International Law Research Program of CIGI. This project has been led by Armand Demetral. He is a senior fellow with the International Law Research Program at CIGI. He's also the Jean Monnet Chair in Law of International Economic Integration at McGill University. And Armand has put together this program for today with experts from around the world who are going to discuss different dimensions of this question of investor-state arbitration between developed democracies. And so the program, you all have a copy of that. It's divided up into 5 panels with an introduction to start the day by Armand. And then we have a lunch speaker who is the ambassador of the European Union, Marianne Konings, who will also discuss this issue from a